Good morning, this is your Kelso Report for Friday, January 11th. I'm your host, Clark Kelso. In our first case today, the United States Supreme Court will deal with the question of mootness in the context of a trademark infringement action and a covenant not to sue. Then we turn to a second decision from the High Court involving statutes of limitations and conspiracy. Our third case, the Ninth Circuit considers the doctrine of preemption in the context of a suit involving medical devices. And then we close with a second district decision involving negligent infliction of emotional distress and bystander liability. The doctrine of mootness is designed to make sure that federal courts adjudicate only live controversies. It is part and parcel of the case or controversy requirement for triggering Article III jurisdiction. But it can be tricky to determine when a controversy between two parties has actually become moot. And in particular, courts have to be careful to avoid letting a defendant who has been sued over ongoing conduct moot out the suit by simply stopping the offending conduct. The problem is the defendant could, after the case has been dismissed, re-offend, thus triggering another lawsuit. To prevent this from happening, the Supreme Court has created a voluntary cessation doctrine, which essentially forces the defendant to bear the formidable burden of showing that it is absolutely clear the allegedly wrongful behavior could not reasonably be expected to recur. The applicability of the voluntary cessation doctrine to a trademark dispute was before the Supreme Court in Already v. Nike. And the issue here was whether a covenant not to enforce a trademark against a competitor's existing products and any future colorable imitations moots the competitor's action to have the trademark declared invalid. The issue arose when Nike sued Already for trademark infringement. Already counterclaimed for a declaration of invalidity, and then Nike executed the covenant not to enforce the trademark. The Second Circuit held the case was moot, given the breadth and clarity of the covenant not to enforce the trademark, and the Supreme Court unanimously affirmed. Already argued that the continued registration of the trademark was a sufficient injury, notwithstanding the covenant not to enforce. But the court rejected this concern as too speculative, given the breadth and clarity of Nike's covenant. Now, we're going to have to wait and see, I think, whether Nike's strategy is adopted by other large trademark holders as a way of hanging on to registrations of essentially invalid marks to achieve a competitive advantage. My own view is that if strong evidence of this develops, the Supreme Court may have to revisit Already's argument in the future. Next, for the Supreme Court, we have a case involving statutes of limitation in a criminal law context. Conspiracy is, of course, an ongoing crime, and as with all ongoing offenses, the limitations period essentially starts anew every day, so long as the conspiracy continues. But what happens when a member of the conspiracy withdraws? Well, the law is clear that a defendant who withdraws outside the relevant statute of limitations period has a complete defense to prosecution. In Smith v. United States, the court considered the issue whether, when the defendant produces some evidence supporting such a defense, whether the government must then prove beyond a reasonable doubt that he did not withdraw outside the statute of limitations period. The court unanimously rejected the defendant's contention that the burden shifted to the government once the defendant put forward some evidence of a withdrawal outside the limitations period. As the court explained, establishing individual withdrawal was a burden that rested firmly on the defendant regardless of when the purported withdrawal took place. And since withdrawal was an affirmative defense that did not negate an element of the crime, there was no due process violation in allocating to the defendant the burden of establishing that defense. The defendant does not get off the hook by demonstrating only a possibility of an affirmative defense. we turn to the Ninth Circuit. In a decision that may trigger a Supreme Court review, the Ninth Circuit held in Stengel v. Medtronic, in bank, that a state law claim alleging breach of a state law duty of care to report known risks associated with the use of its pain pump medical device to the Food and Drug Administration was not preempted by federal law, notwithstanding the federal agency's approval of the pain pump under the Medical Device Amendments of 1976. Now, preemption in the context of federally approved medical devices is a complicated field of law. The Medical Device Amendments contained an express and broad preemption provision to the effect that, quote, no state or political subdivision of a state may establish or continue in effect with respect to a device intended for human use any requirement which is different from or in addition to any requirement applicable under this chapter, close quote. Now, this language leaves open the possibility of state laws that are not different from or in addition to any requirements under the Federal Act. That's what the Supreme Court has previously held. And the problem, of course, is that most state law product claims would possibly be different from or in addition to the federal requirements. For example, a state law claim based on design defect allegations would seem to be directly contrary to a federal approval of the product as designed. Well, alert to this problem. The plaintiffs in Stengel proposed to file a second amended complaint with a rather peculiar state law claim that is premised on the drug manufacturer's failure to report to the FDA all known risks associated with the use of its product. The breach of that federal duty to report to the FDA would become the basis then for a state law claim. The Ninth Circuit en banc unanimously concluded that this claim could not impose any requirement different from or in addition to the Federal Act, and was therefore not preempted. After all, the claim is based on the FDA's requirement that they report to the FDA. As the Ninth Circuit noted, given the nature of this claim, the plaintiff ultimately is going to have to show that the failure to report to the FDA was the cause of the plaintiff's injuries. That's a different causation inquiry than you normally would have in a products case. It's going to be interesting, I think, to see if the Supreme Court leaves this decision alone, since it does appear to have threaded the needle. Or the Supreme Court may decide that this pleading is just an illegitimate way of converting a federal reporting requirement into a state law cause of action to be brought before a state court jury. Finally, we have a case involving bystander liability. Now, bystander liability and negligent infliction of emotional distress is one of the ugliest ducklings in California's flock of tort causes of action. In the leading case of Thing v. Lechuza, the Supreme Court of California, about 23 years ago, established 3 mandatory requirements to state a claim for negligent infliction of emotional distress under the bystander theory. First, the plaintiff has to be closely related to the victim of the accident. Second, the plaintiff must have been present at the scene of the injury-producing event at the time it occurs and be then aware that it is causing injury to the victim. And third, the plaintiff must suffer severe emotional distress of a type more than would be suffered by a normal person witnessing such an accident. Well, the Second District in Foreman versus Forvaltningsbolaget Insulan faced a situation where the plaintiff witnessed her brother's death while they were scuba diving off the coast of Catalina Island. But she attributed his distress underwater to a heart attack, until a subsequent investigation later revealed that a plastic flow restriction insert manufactured by the defendant had broken off and become lodged in her brother's second-stage regulator, thereby preventing him from getting enough air to breathe while underwater. Well, applying the limits set forth in Thing, the panel rejected the plaintiff's claim, noting that Thing requires a contemporaneous perception of what caused the injury. Since the plaintiff did not have the contemporaneous perception, she thought it was a heart attack, her NIED claim fails, and the trial court properly granted summary judgment to the company. Now, the result here does seem to be a correct application of the requirements set forth in Thing, but the result certainly makes one wonder about the fairness and justice of those requirements. I doubt, however, that the current Supreme Court will want to reopen the bystander liability can of worms. So my guess is that this decision will stand. And that's it for today's Kelso Report. Have a great day in the law.